Upside Quickie. 5 years ago, I made a quickie saying that Roe v. Wade and Casey v. Planned Parenthood weren't at all likely to be overturned. Yep. Got that one wrong. In Dobbs v. Jackson Women's Health Organization, the Supreme Court 6-3 overturned both Roe and Casey. One reason I didn't expect this was the respect conservative judges have for stare decisis. But as the majority explained, there are reasons to go against it in this case. I mean, you don't want rulings like Plessy to stand, right? Roe and Casey both read in an implied right to abortion using the Palco test from 1937's Palco v. Connecticut. A right is constitutionally protected if one of two criteria apply. One is if it's either directly enumerated or fundamental to the exercise of an enumerated right. Roe and Casey didn't even try to say that was the case with abortion. That left the other option. A ban would violate a principle of justice so rooted in the traditions and conscience of our people as to be ranked as fundamental. But that just wasn't the case with abortion. Abortion was illegal in every state, and in states that made a move towards slightly easing restrictions, it spurred massive protests. And by 1973, there was no state court, federal court, legislature, founding document, opinion of the founders, public opinion piece, legal treatise, or anything that said that abortion was a fundamental constitutional right. Roe and Casey didn't even try to show the constitutional basis. They just asserted it was there and gave future courts no guidance for how to apply it. At the time of Roe, there just wasn't a tradition or conscience of the people recognizing the right to an abortion. Therefore, the court misapplied Palco and the precedent is invalid. So pro-choicers didn't get what they wanted, which was a constitutional right to abortion. But the pro-lifers didn't get what they wanted either, which was the fetus being recognized as a person under the 14th Amendment. Instead, the court said the issue required a balance between recognizing the bodily autonomy of the mother and the state's interests in protecting the life of the fetus, or potential life to use the language of Casey. But that's a legislative function that has to be hammered out in the state legislatures. It's not something for the court to just cook up on their own. And it should not be the function of the Supreme Court to take sides when there's such a deep divide among the people. By the way, don't listen to the fearmongers. The opinion is explicitly clear that this was a fundamental difference in kind to other rights such as marriage or contraception. Since there's no potential life with a conflicting interest, the ruling just doesn't apply to them. Basically, the ruling was to just toss it all out as an unworkable mess and tell the states to start over again. And get it right this time. And you know, this one case has been the point that everyone was screeching about every time there's been a new justice to be appointed, as if this one issue should be the litmus test for approving a justice. So who knows, at least now there might be actual debates on how good they are on the Constitution. Silver lining.